We're here today for a hearing on bail. I have reviewed the people's papers requesting that the court deny bail, and I have reviewed all of the findings filed by Mr. Millette requesting that the court deny that request and set bail. Other than what is in your papers, Ms. Bowles, did you want to be heard?
Yes, Your Honor, just briefly.
Go ahead.
Your Honor, as I indicated in my brief, I am asking that the court leave bail as set, which is no bail pursuant to the California Constitution, and the analysis under Humphrey. And that's essentially based on, as I indicated, that Maya Millette would not have abandoned her children. She could not loved them very much, and that in 2020, when she took steps to emotionally leave this marriage, physically leave the marriage, she took that into account, her children's well-being into account. And as it got to be too much, she then did essentially take those more substantive, concrete steps to file for divorce, and communicated that to the defendant. He acknowledged that he was aware of how serious it was to several people, and he unraveled. And it was a desperate man who became very dangerous then, and the desperation led his desire to hurt anyone he felt might be a threat to his family unit. His family unit was everything to him. He did not have a lot of outside interests, a lot of outside friends, and his family unit was everything, and a threat to his family unit resulted in his desire to harm anyone who might get in the way of keeping that family whole. And it's ultimately what led to the murder of May. And it's that is the backdrop for my argument with regard to the California Constitution. He was, as I indicated, communicating with these spellcasters. It's an unorthodox and, I would venture to say, sinister way of trying to control another person. But in those communications, and to be clear, it's very unusual, so just to be clear, there are email communications between the defendant and these spellcasters where he is specifically providing insight into his state of mind, which is very dangerous and concerning. And as I indicated in one, he was wishing a death spell, harm to the person he believed was having an affair with his wife, wanted harm to come to that person's child. He asked for, at one point, a family member of May's asked if there was someone that he could identify to essentially pay to get the other guy, again meaning this individual. And these emails, to be clear, they were obsessive, they were frantic, and they became increasingly so up until January 7th. He essentially was losing control, and as of January the 9th, those messages then shift. They shift from wanting to make May a subservient wife, obey him, to not leave him, to stay with him for all eternity. They shift, and they then move to this man that she was believed to have been having an affair with. And he wanted that man to be punished for, again, breaking up, in his mind, this family unit. He was the reason for that. And so what's clear is that when he feels like he's losing control, he can become violent. And so it's our concern that now that murder charges have been filed, that level of control, that feeling of being out of control is even more pronounced. And so that anyone who is the cause, essentially, of his crumbled marriage, of his now broken family unit, would be the target of violence at his hands because of that. And so we feel that now that threat is even more pronounced. And then secondarily, on the Humphrey analysis, he is a flight risk, I think, as indicated in the brief, but more importantly, there's a public safety concern. The children, as the court is aware, are of paramount concern here. And again, the defendant had a desire, an overwhelming desire that really took over and caused him to be violent, to keep that family intact. And it's our concern that if feeling threatened again, what desperate measure might he take to, if he feels that his ability to remain intact with his children, what desperate measure might he take? Additionally, They are collateral victims of domestic violence here in this case. They were at home when this incident occurred. We have information that they had been, that there had been property damage in the home when the defendant had been angry on prior occasions. And there had been manipulation tactics by the defendant to control and manipulate May, and I think it is reasonable to believe that he would transfer those to his children as well. He used his child's phone to track his wife on prior occasion, and so it is concerning to us. And again, the CPO violations that we heard last week are evidence that he is not able to follow a court's order, and that he is, it's a glimpse into manipulation tactics that he would use to influence his children in this case. We know he has several, had several firearms, and even after a gun violence restraining order was issued, there's still a gun that is outstanding that he has been unwilling to provide to law enforcement. And these emails provide a very, very concerning insight into his state of mind, his instability, and his dangerousness to the community. So based on those arguments, I would ask the court to leave bail at no bail. I know the defense filed a motion as well, and now I don't think is the time for us to litigate the facts of the case. It's not time for me to start arguing about all of the things that I disagree with in terms of what facts they claim to be out there, and provide, photos or messages of May and showing her love and concern for her children. But what I would say that is interesting about the filings is that I think it provides a window into the level of manipulation, is the best word I can say, with regard to the children in the home with their grandparents and with the defendant, and that they're being told that their mother walked away, didn't love them, abandoned them, I think is a tragedy in and of itself. So I don't think there's anything with regard to the defense motion that provides a basis to stray from what the arrest warrant, the no bail that was requested in the arrest warrant, and based on those arguments and the arguments that I've submitted in my brief, I would submit to the court.
Go ahead and address the issue of bail.
Thank you very much, Your Honor. Your defense have filed, I believe, enlightening data and facts to show that the defendant is not a flight risk and he is not a danger to society. There has been no record of any violence whatsoever in his entire life. We showed you his service in the military, and continuing up to the present time, he's still serving the military in a civilian capacity. I believe we submitted to the court data that verified all of that. There is still no record of any violence or any misconduct whatsoever. It shows that this man is even in charge of the security of this Balboa Naval Hospital, in charge of security. And we also showed you statements from the public who knew him all this time. We also submitted to you this data about the lifestyle of the alleged victim. It shows her lifestyle. What essentially we're arguing, Your Honor, is this. You cannot exclude other hypotheses of her disappearance.
But Ms. Martinez, again, the court is required to assume that the charges are true when addressing the issue of bail. Today is not the day to try the case.
I understand you.
That's why I'm arguing that, in fact, he never flew. There is no evidence that he tried to escape. He had 9 to almost 10 months. He did not flee. He didn't escape. We are willing for him, Your Honor, to even wear a bracelet to monitor his whereabouts. He's willing to do that. He needs, if you want him to require his passport to be present, to be in custody of the DA, we are willing to do that. But, at least I've spoken to his employer, And they indicated to me he still has a job. And if he doesn't get back to his job, you know, they can't pay bills. And so I think it would be safe for him to be out, even if, you know, he's willing to have that bracelet and limit his movements from home to work, vice versa. And so I don't see why he shouldn't be on bail on the basis of that, Your Honor. He's willing to agree on restrictions that the court would impose to assure his presence for trial.
All right, thank you. Again, as the court stated, the court is required to assume that the charges are true when addressing the issue of bail. Mr. Millette is alleged to have killed his wife in their home while his 3 children were present. He's also alleged to have taken their 4-year-old son with them to dispose of her body. On 2 occasions in 2020 and early 2021, he inquired about finding someone to get the other guy, referring to a man with whom he suspected his wife had an affair. On one occasion, he even stated he was willing to pay $20,000 to accomplish this. 1 month prior to killing May, he performed internet searches regarding means to incapacitate and or cause harm to someone to make them never wake up. He contacted spellcasters to request death spells to be placed on both his wife and another man, the man previously mentioned. In one of those requests, he even intimated that he wished for harm to that person's unborn child. Even after her death and disappearance, he emailed the spellcasters requesting punishment for this man. He possessed several firearms, some of them unregistered, and he failed to or did not comply with a validly issued gun violence restraining order. Due to his noncompliance, a search warrant was executed to collect the firearms, and one remains outstanding. He's failed to comply with the criminal protective order, prohibiting him from contacting his children. The court therefore finds there's clear and convincing evidence that he's threatened to commit grave bodily injury against another, and there's a substantial likelihood he would carry out that threat if released. Additionally, there's clear and convincing evidence that he's a danger to the community. His request for bail is denied. People's request for no bail is granted. He'll remain in the custody of the sheriff without bail. I will confirm his readiness conference that is currently set for December 16th at 1:30 in Department 16. All further matters in this case will be heard by Judge Mooring. And I will note again for the record that at each and every hearing we'll have the listening device provided. Thank you. This hearing is concluded.